Assalamualaikum to Dr. Muhammad Nazir. Today we would like to present about termination of the employment contract during the pandemic. We are from group 18. My name is Rabia binti Sakimat. I'm with Rabiatun Nazwa binti Nur Zubaidi and Raihana Akila binti Hamidi. I would like to begin my introduction about termination of employment contract. Termination of employment contract refers to when an employee's employment with a company or organization comes to an end. A contract between two parties for the exchange of goods and services is a legally enforceable agreement. Contracts can be oral or written, but it's usually better if they are written down and signed by both sides. Unemployment during the pandemic caused a severe problem, especially during Malaysian Movement Control (MCO). The government restricted people from going outside except to buy necessities, which meant that people were not able to find jobs. During the pandemic, millions of people around the world are at risk of losing jobs and income. Constructive dismissal happens when the employee is forced to discharge, whereby they are given an ultimatum to quit or be fired. Next slide is about discussion about termination of the employment contract. There are several existing legal laws or rules to overcome termination of the employment contract, and one of them is the Malaysian Employment Act 1955. First I'm going to talk about Malaysia Employment Act 1955. When an employment contract is terminated, most companies or organizations give a 2-week notice of an employee's termination. According to Malaysia Employment Act 1955, the length of such notice shall be the same for both employer and employee, and shall be determined by a provision made in writing for such notice. In the terms of the contract of service, or in the absence of such provision in writing, shall not be less than 4 weeks' notice if the employee has been so employed for less than 2 years, 6 weeks' notice if he has been so employed for 2 years or more, but less than 5 years, and 8 weeks' notice if he has been so employed for 5 years or more on such dates. Furthermore, Section 60N stated that the employer must first remove foreign employees before terminating the services of local workers. Next is, if the employer fails to comply with the provision of Employment Act 1955, the employer may be fined up to 10,000 ringgit Malaysia if convicted under Section 1998 of AK 1955. All benefits or compensation must be paid within 7 days of the contract termination date. Rule 11 provides for these situations. Furthermore, the business must produce a written declaration regarding the payment of remuneration to its employees. Failure to do so will result in the employer committing an infraction under Regulation 12 in bracket 2.
Today I would like to explain to all you about Industrial Regulation Act 1967. Regulation Act 1967 allows employers and employers to independently determine their representative. This amendment also allows the industrial court to reduce compensation without being bound by the secret schedule. This process given appeal within 40 days to the High Court. Worker also can be protected through termination of service to access manpower, layoff, and rehabilitation. They can make a complaint to claim their rights. Worker also can direct complaint to the Director General of the Department of Industrial Relations within 60 days from the date of the termination of work. The employers has the right to bring the case of dismissal to the industrial court. That's all. Thank you.
Okay, to sum up, we must acknowledge that the spread of this virus is beyond our control and has impacted negatively on the country's economy in all sectors. Employers, on the other hand, should be involved in the resolution of any COVID-19 issues that emerge. Workers can withstand the COVID-19 epidemic to some extent if they cooperate to build an effective plan that includes efforts to enhance the country's economy. Employers should gain a better understanding of their employees' problems during the COVID-19 outbreak. Okay, normally, some of them may be experiencing financial struggles, familiar problems, and internal stress during this COVID-19 pandemic. So, employers should refrain from terminating employee contracts or firing workers. What we can see, many employees were laid off or had their employment contracts were cancelled due to surplus workers in the organization during the COVID-19 pandemic. Employers also terminate employees in violation of government rules. As a consequence, the position of the employer may be affected. The employer could be held accountable for wrongful termination, Section 20 APP 1967. Workers, on the other hand, have it particularly good when there are restrictions in place to prevent them from being abused. As a result, these two pieces of law have mostly protected the faith of employees who are oppressed by their bosses. The Employment Act of 1955 and the Industrial Relations Act of 1967 are two of its acts. Both of these acts are capable of ensuring the welfare of employees at all times. So, employers no longer be able to exploit their employees under these two acts.